Hello, everyone. Let me just adjust my camera here. Hello, and welcome to today's webinar, Lawyering Without Legalese. My name is Andy Davis, and on behalf of our team here at Expert Legal, I'd like to welcome you and thank you for being here. Just to give you a sense of what's going to happen today, the presentation will last for about 25 to 30 minutes. And during that time, if you have any questions as we go through the material, I'd like to encourage you to leave them in the Q&A box that you should see at the base of your screen, rather than in the chat box. And at the end of the presentation, we will be addressing all of your questions as we go. So let's get right into it. First of all, when we say lawyering without legalese, what do we mean by legalese in this context? And we can all agree that legal language and legal writing is almost a world unto itself. But the point that we want to make just at the outset is that we're not talking about things like legal terminology necessarily, or legal definitions, defined terms, or even terms of art that might be used in a given practice area. So for example, in a contract, you might see something like force majeure, or in negotiating a contract, people might refer to a carve-out, meaning an exception to a covenant or a rule. In litigation, you might hear res judicata, meaning that a decision has been rendered already by this competent court. So these are the kinds of terms that, even though they're used strictly in a legal context, they're not legalese per se. What we are talking about when we refer to legalese are words that are archaic and stuffy, words that would have disappeared a long time ago without anyone missing them, if not for us lawyers. We're talking about words that are cryptic or confusing, that are almost designed to have your reader run for a dictionary. It's also jargon that you don't really need. And again, this is different from a term of art that has a specialized meaning. Jargon here in this context is referring mostly to words or phrases that don't enhance a reader's understanding and that could just be put in simpler terms. And finally, legalese is that overly wordy style that a lot of lawyers seem to feel is a hallmark of good legal practice. You know, there's that old joke about lawyers being paid by the word, but we're trying now to find ways to get around that. If it can be said in 10 words, why say it in 50? That's not what we mean to do. It should be the opposite. Second. So in case you're not yet quite convinced of the problem, I want you to know, my friends, that science has now concluded officially that legalese is bad. We wrote about this in a recent blog post on our website, and I've linked to that blog post in the chat box. You can take a look at that. But for those of you who might have missed it, I'll just summarize. So a team of researchers have compared contract language to language drawn from newspaper articles and just a variety of other everyday sources. And they found that contracts contained alarmingly high proportions of the kinds of problematic words and stylistic choices that we're going to be discussing today. It's a fascinating study, so I encourage you to read it if you haven't done so yet. I also want to acknowledge that even though we're advocating here for simplifying your writing style, it shouldn't come at the expense of expressing complexity and nuance. So simple does not equal simplistic. As lawyers, we always understand that there's a tension between needing to be understood, and that's especially true when you're working across language barriers and across legal systems. And at the same time, maintaining a high level of sophistication and indeed elegance in your legal writing. So keep this balance in mind as we go through the recommendations today. And finally, just a quick word before we proceed. All of the examples that I'm going to share with you today have been taken from actual writing samples of attorneys that we've worked with over the years. So for those who might not be familiar with our work, we at Expert Legal specialize in creating customized courses that use attorneys' own written work as the course materials. And I'll say a little bit more about that at the end of the presentation, but for now, I just want you to know that if, as we're going through this, you start to feel more and more guilty about your uses of legalese, you should be assured that you're definitely not alone. And in fact, many native speakers make these mistakes as well. All right. So with that preface said, let's get into it. Here is how we can reduce jargon and build understanding with English language clients or English language readers generally, really. And the first thing that we recommend is to simply reduce or ideally eliminate jargon. And to do that, there are 3 habits that are common to legal writing that you can start to eliminate right away. The very first one, and apologies in advance if I'm going to be breaking any hearts when I say this, but my friends, you have to eliminate here and there words as much as possible. And by here and there words, I mean those words we see all the time in contracts, legal briefs, opinions, words like herein, therein after, kinds of words that only lawyers and almost nobody else but lawyers tend to use. And if only lawyers write like this, that's a good clue that maybe there is a clearer, better way to say these things. For example, instead of herein, you can just say in this document or in this agreement. Instead of there and after, you could say after that, let's say provision in another document to make it clear. Instead of aforementioned, you could say that, for example, the aforementioned agreement, that agreement, or the agreement mentioned above or mentioned previously. This is the way that normal people talk. As a good rule of thumb, if there's a clearer and more commonly used way to express yourself, again, without sacrificing nuance or complexity, then you should probably use that instead of these kinds of archaic constructions. So let's take a look at how we can swap out such words. In this writing sample, the sentence is, the parties respectfully request that all information presented herein be kept confidential. Now we can upgrade this sentence, right? We can say, the parties request that all information presented in this report be kept confidential. And I've put in this report in parentheses. Why? Because depending on the context, we might not even need in this report. We can just say all information presented be kept confidential or all information be kept confidential. And notice in this example that not only have we dispensed with the old-fashioned herein, but word respectfully. And the reason that we can try to do this in this case is that the respect is implied by the use of the word request here, as opposed to something stronger and more aggressive like demand, let's say. Now, once again, if the context requires, for example, let's say that you're presenting this to a judge or a tribunal, if the context requires an extra level of deference, then there's nothing wrong with using respectfully. But if you can eliminate it, if context allows you to eliminate that word, why not go ahead and do it anyway? Here's another example. Invoices for global services and other categories of payment specified therein. This can become invoices for global services and other specified categories of payment. So keep this in mind if you're inclined to use here and there words, especially if you are thinking of them as a way of elevating your English writing. They're not necessarily better. And in fact, they can make your style seem needlessly stiff and old-fashioned. And I'll just share with you a little confession. In some ways, I'm talking to myself here because, you know, as a lawyer, especially in my earlier part of my career, I really enjoyed using here and there words. It made me feel like a real lawyer. But the plain English movement and just common sense suggests that we try to speak more and write more the way that people really write and really speak, so we are better understood. So I'm guilty of this myself, but my friends, I encourage you, don't do what I did. Avoid using here and there words. The next habit I'd like to address that we lawyers are often guilty of is what I call throat clearing. And this is, you know, those wordy transitions or prefaces or turns of phrase that we often see, but could be condensed into fewer words. Examples like with respect to, pursuant to, for the purpose of. In all of these examples, and probably many more that I could share with you, there's simpler, just sleeker ways to say what you mean. With respect to could just be about or concerning. Pursuant to, you could say under, pursuant to this agreement, under or according to. And for the purpose of, you could just say the word to. For the purpose of, to do such a thing. Now, again, there may be times when it's more elegant or you need to be a little bit stiffer and more formal. It may be more appropriate to say with respect to than about or concerning. The context might require more delicacy, or in some cases, the shorter option might come across as a bit abrupt or indelicate. So you should keep these dynamics in mind, and that includes also certain cultural contexts in which saying something as directly as about or concerning would strike your reader as a little bit hostile. So keep that in mind when choosing your language. But again, where possible and where the context permits it, you should opt for the more concise choice. Now let's look at an example of throat clearing in action and how to avoid it. In this writing sample, we can see the parties will negotiate in good faith pursuant to the provisions of Article 12. Now, admittedly, this isn't heinous, but we could modernize it by saying, for example, the parties will negotiate in good faith according to the provisions of Article 12 instead of pursuant, or the parties will negotiate in good faith on the terms set forth in Article 12, again, depending on your context. So notice that here, especially in the second example, we've sacrificed brevity for modernity. The sentence is now longer, but at least it's now upgraded in the sense that it's less legalistic. Okay. The third bad jargon habit that I want to discuss with you is the tendency to use synonym strings. Now, synonym strings are groups of words that mean exactly the same thing, but we as lawyers tend to invoke them all together like a magic spell, almost as if we fail to say one of the words that means the same thing as the first word we said, that somehow our carefully crafted document will fall apart. And you've seen some of these synonym strings, things like null and void, cease and desist, indemnify and hold harmless. These are classics, right? Synonym strings are so entrenched as a convention in English legal writing that despite now 4 decades of the plain English movement, a lot of lawyers are afraid to take the step of avoiding them and just using one word instead. But we want to encourage you, our dear friends, writing in English as a foreign language, to try to do so. It really is okay. You can say void instead of null and void. Instead of cease and desist, you can say stop or cease. Again, keeping the context in mind. However, on cease and desist, I want to acknowledge that there is, of course, such a thing as a cease and desist letter, which, for example, an attorney might send to stop someone from infringing on a copyright, for example. In that case, cease and desist as a letter, as a form, an instrument, has become a term of art. So this is not an example of a synonym string. Try saying that fast 5 times. Cease and desist in that case is okay because you're referring to a specific instrument. But for other contexts, it'll usually be better to avoid a synonym string if you can. Nothing's lost by using one synonym instead of a synonym string. And indemnify and hold harmless, you can simply say indemnify. But I want to point out that that doesn't mean that all strings are bad. It's okay to list a number of words all together. It just means that when you find yourself creating a string of words separated by commas, all to get at the sense, the full comprehensive sense of what you're trying to convey, you should take the extra time to double check and see whether you really need all of those words. If any of them is a perfect synonym of the other term, then you should strongly consider eliminating it. All right, so those are the tips for tackling jargon per se. Let's turn now to some of the recommendations for simply writing in a more streamlined style. This is about streamlining your sentences. And we have 3 recommendations in particular for embracing a more minimalist style in your writing. The first is simply to just use fewer words. Here is a phrase, for example, that we see all the time. Set forth below, please find. Can this be minimalized? Of course, we can simply say below is or below are. And I apologize if you're hearing a siren outside. This is New York City. There's sirens all the time. So we can, instead of saying set forth below, please find, which is a quite archaic construction, we can just say below is or below are. All right, now take a look at this sentence. And I'm sharing it with you today for a very particular reason. When you are writing in English as a foreign language, especially, shorter sentences can help you avoid mistakes or confusion. So take a moment to read through this example, which was taken from, and again, another writing sample from a student we had several years ago. In this example, the student says, it would be permissible under the law if client make arrangements in the agreement that expressly stipulate distributors are obligated to provide certain level of quality maintenance services to customers, and client is entitled to terminate the agreement where distributors fail to fulfill such obligations. That's a mouthful. I need to take a breath. Now, you can tell that the writer is trying to express a clear idea here. But the more words they use, the less clear the idea becomes. On top of that, this long sentence increases the risk of making errors of grammar, syntax, and spelling, as you can see here. So in this case, this writer has sacrificed clarity and also undermined their own legal expertise and professional standing simply by writing an overlong sentence. Now, I want to acknowledge that it can be sometimes harder to write a crisp, short sentence that conveys everything you're trying to say than a long, overstuffed sentence like this. And if you find yourself in this position, if you find yourself going on and on and on before you get to the end of your sentence, stop and take a step back and take a good look at your work. Check to see where you can trim and condense it, keeping in mind, for example, the jargon cutting tips that we shared earlier, and see if there are things that you can leave out that don't add to the understanding of what you're trying to convey. And I really think that had this writer taken the time to do that, they might have ended up with a sentence that looked more like this. The law allows client to expressly bind distributors to certain customer service standards and to terminate the agreement should distributors fail to meet them. This sentence fully conveys what the writer was trying to get at in the previous version in a concise way. So look at your sentences that are particularly long and ruthlessly edit them to see what you can trim. And then ask yourself at the end of the day, is this clear? Have I made myself clear or have I created confusion? So shortening through ruthless editing and careful rereading is very important. Another way to streamline your text is by using adjectival nouns. Now, English has this great device which allows you to turn your nouns into adjectives, eliminating the need for connectors like of and the. So here's a simple example. A shareholder of the company can simply become a company shareholder. And again, depending on context, you could even say a shareholder. Or look at this one, guidelines regarding employee profit sharing can simply be employee profit sharing guidelines. So when you're writing, read back your work to see where you might use an adjectival noun to shave a few extra words off of your text. A similar device in a similar vein to adjectival nouns is to unbury any buried verbs. Now, a buried verb is a verb that really wants to be a verb. It wants to be an action, it wants to be dynamic, it wants to be a doing or telling word, but instead it's trapped in the prison of being converted to a noun. So here, for example, instead of saying the cost of the promotion and marketing materials, you could say the cost to promote and market materials, thereby turning promotion and marketing into promote and market. It's more dynamic. It's like a shot of adrenaline. Or you could say, again, depending on context, you might even say promoting and marketing costs. Instead of procedures for the deletion of personal data, what might you say? You could say procedures for deleting personal data. Now, notice in the case of this example, we don't recommend something like personal data deletion procedures. And why is that? Well, because even though this is indeed shorter, we've gotten rid of the word for, and we've turned the noun deletion, and it turns the noun deletion into an adjectival noun, deletion procedures. The final result is still a bit clumsy and awkward. So again, remember, the goal is to be clear, crisp, and professional, as opposed to just being brief for brevity's sake. So as much as we have been encouraging you to write brief and concise sentences in a more modern style, it should never be sacrificed. You should never sacrifice clarity and professionalism for that sake. So a passage like this, personal data deletion procedures, gives the reader something to unpack that they might not otherwise need to unpack if you just said procedures for deleting personal data or procedures to delete your personal data. So those are some ways to streamline your sentences. Let's turn now to a final but very important tip for crisper and more effective writing. And that is to use the active voice. My friends, the passive voice addiction is ubiquitous in legal writing. What you're seeing on the screen here is a chart that was taken from that legal writing study I mentioned earlier, which again, I encourage you to read. And you can see here that compared to other forms of writing, academic writing, blogs, fiction, newspaper articles, even the Wall Street Journal, that lawyers remain by far deeply addicted to the passive voice by several orders of magnitude. And yet using the active voice is so dynamic. Look at the examples on the left here in red. Reference is made to the standby letter of credit. The management of the company shall be carried out by a board of directors. The following is agreed and acknowledged by us. You might be used to seeing these, so they might not strike you as particularly wrong, and indeed they're grammatically correct. But look at how much more modern and dynamic it is to restate these sentences using the active voice. We refer to the standby letter of credit. A board of directors shall manage the company. We agree and acknowledge the following. It's simple, it's straight, it's direct, it's the active voice. Now, having said that, there are cases when it is better to use the passive voice, and let's look at two of those. The passive voice is better if you either don't know or you want to de-emphasize the actor or the subject. So in the example here, instead of saying, I recommend that layoffs be made and taking ownership and direct responsibility for a sensitive decision, you might want to be more delicate and say, it is recommended that layoffs be made, and just obfuscate who's doing the recommending. The passive voice is also better when you want to emphasize the result of an action rather than the action itself per se. So here, instead of saying the client should not underestimate the risk of fines or other sanctions, you might want to rephrase that, because in this case, it's the fact that there are fines and sanctions and a risk of fines and sanctions that's important, rather than who should be estimating or overestimating them. So you might rephrase that to read, the risk of fines or other sanctions should not be underestimated. But these kinds of exceptions aside, I hope I've convinced you to be part of the solution to overcome our collective professional passive voice addiction. Whenever possible, please use the active voice. Okay, let's now recap what we've gone through today. Remember to reduce or eliminate jargon using the ways that we have recommended. There are 3 habits to avoid. Eliminating as much as possible your herein befores and your thereupon and theretos. Avoiding throat clearing language, those kinds of flourishing languages, unless, again, the context, it dictates that it's better to use them. Finding the courage to abandon your synonym strings and just using the right word instead of 5 words that mean the same thing. Once you've eliminated jargon, think about ways you can streamline your sentences using the ways we've talked about. 1, shortening them just by ruthless editing and also rereading for clarity. Using adjectival nouns to get rid of small connectors like of and the wherever possible. And unburying those verbs that want to be verbs and not nouns. And finally, last but by no means least, using the active voice. Okay, so this brings us to the end of the presentation. I now will open it to any questions. I'll see if anyone's got a question in the box here. No questions so far. I hope this has been clear to you. You can ask any questions if you have any, but in the meantime, let me move on to just a small indication before we close of the way that we work at Expert Legal. I promised I would mention a bit more about who we are and what we do at the end of the presentation. So as I said earlier, our specialty is in customized courses for lawyers and legal professionals who need to work in English as a foreign language. We work virtually or in person with clients all over the world, whether law firms, legal departments, government ministries, bar associations, we run the gamut. And what's unique about the way that we work is that we create customized courses using your written work as course materials. So we don't have, for example, a generic course book where you can just learn English from start to finish. In fact, we're not really English teachers. We think of ourselves as legal writing perfecters. We take samples of your work and we assess exactly where you need help and design a course that's particular to you or to your group. And this allows you to focus only where you need to and not to waste time going over things you've already mastered or that don't apply to your work. So if you're interested in learning more about us or the way that we work, I encourage you to reach out to us via our website. And finally, before we close, I'd like to encourage you to join us for our next webinar, which is taking place on Thursday, December 1st. And this one is called Racing Against Robots: What Clients Expect from Human Lawyers in an Age of Automated Lawyering. It's going to be a lot of fun. And of course, as always, we'll be addressing it through the lens of writing in English, legal writing in English as a foreign language. So that's it from us here. I thank you so much for being here today. We hope that you found this material useful, and we hope to see you at our next webinar. Thanks very much. And I'll just check one more time if there are any questions. I see no questions. So in that case, my friends, I will stop sharing at this point, and thank you for joining us today. Goodbye.